Hello, welcome to this week's episode of In Chambers with Mohammed Muigai. Join me this week as I talk to Muigai Githu and David Angwenyi about their journey so far. Thank you again, David and Muigai, for being here for this episode. So I think I'll just start us off with basic introductions, where you went to uni, when you signed the role, and anything around that. And you could start, I think, with Mr. Angwenyi.
Thank you very much. Seniority is very important. I went to university in the Catholic University of Eastern Africa. I went there in 2009, finished in 2012. After that, usual path for advocates, went to Kenya School of Law in 2013, did my pupilage here at Mohammed Muigai, worked a few years until 2018, then went and did my master's in Cardiff University. I was admitted on 4th December 2014, approximately 5 minutes before Mr. Muigai Githu.
Yeah, and Muigai, you're next.
Thank you for that, William. So my name is Muigai Githu. I'm a partner in the Corporate and Commercial Practice Group. I went to the University of Kent for my undergrad. That was 2008 to 2011. Thereafter, I went to the School of Law, after which I later went to do my master's 2016 to 2017. And as has been mentioned by Mr. Angwenyi, we are admitted on the same day, albeit one ahead of the other.
So my second question, it's a bit of a thinker. Okay. So I would like you to tell us, what's the first big purchase you made once you became an advocate? Like once that advocate salary hit your account or the envelope, however it was back in your day. What did you buy?
Back in our day?
Yeah.
This is embarrassing. My first purchase.
Your first big purchase?
Was a PlayStation. Yes, I had a PlayStation 3. So the moment that money checked in, I went for the PlayStation. Embarrassing, but that's what I wanted.
Okay.
That's amazing. You're right, it's a bit of a thinker because it was some time ago.
Yeah.
Quite.
It was well a decade. It was a decade.
We're almost.
Yeah, we are getting to a decade. What was it? At the time, I don't recall a big purchase, but I do know what I did immediately. And at the time, I was working with a very close friend of ours, who I'll not name, but he knows. And we went and had a very big drink in town where I was working for some time. So that was the first thing I did. I can't remember the biggest or the big purchase, but that was the first thing I did to celebrate that transition.
Yeah. And also for the audience, there's something Muigai omitted in his introduction, that he doubles up as well as my pupil master. You didn't.
That is also true. I also double up as your pupil master. There are many things I didn't say in the introduction. Such as how David was ahead of me on the date of admission, an injustice that is still being investigated. So I can't talk about it too much.
Okay.
Yeah, but they're looking into it.
Okay.
An old injustice, but it shall be dealt with.
So as of December last year, you both made partner at Mohammed Muigai LLP, and you're fairly close. I think for the audience that their offices are right close to each other. And as people who work in MM would tell you that if David isn't in Muigai's office, Muigai is in David's office. David, I'm just saying. So now the question that follows is, how did you get close and how did your friendship start?
I just wanted to correct something. It doesn't mean we don't work.
I haven't said that.
Yes,
Actually, for the record, I've gotten more work when you're both together in one
That's
office.
when we're at our most efficient.
That is when the consultation
sure.
is peak.
Yes.
The consultation is very high. It's something that we do. So to surprise you, well, maybe not to surprise you, David and I were acquaintances before I came to work at but we weren't particularly close. I think we just, you know each other. And then the difference was and I think where your question comes from is also because we work in different disciplines. So very rarely do we work on the same file. I think the thing that made us close, and I think genuinely even helps us in how we actually work today, because it's true that we do consult quite a bit on work, is because of the acquaintance that existed before. The normal progression of a workplace friendship was sort of accelerated. And therefore, we were able to really grow in the ability of, I want to consult you on this, or I want to consult you on that, or feeling at home with someone to ask certain things. That helped the camaraderie and the friendship to now sort of grow in its own time. Of course, I had a drink with him once or twice over the weekend, which also is a catalyst in itself. Yeah.
When Muigai came, I wasn't very sure what to expect. Someone used to see once a while, do the nod, point at him, and that was the extent of our interactions.
Yeah.
So when we started talking, I remember it was February 2018, if I'm not mistaken. It came on 1st February. I remember the date.
Hey, that's quite impressive.
Yeah, and when he was speaking, he reminded me of our mutual friend. He hates this.
Yeah, I didn't like that you said I sounded exactly like him.
Yeah, but he sounded exactly like him. And we had a chat. Then he decided to transgress the rules of practice. Under the rules of practice, the senior always buys the meal, the drink, what have you. So he decided to buy me lunch. Didn't complain. And from then on, our friendship blossomed. Of course, we started meeting each other outside work, hanging out, meeting each other over the weekend. And we found we have, I think you would disagree with this, please. We have the same view on a lot of things. Yeah.
Yeah, well, on a good number of things. On a good number of things.
Yeah.
The other things we still differ greatly.
Yes, that's true.
If I can,
like the admission.
Yeah, like the admission. But let's leave that to those who are investigating, and we trust them. Let me ask a question, babe, that maybe if you like, do I have powers to ask a question? This transgression you're saying I committed where I bought you lunch, do you ever intend to regularize and you buy me lunch hata mimi ndio nijue vile?
Are you trying to have the audience believe I've not bought you lunch for 7 years?
Okay, I'm asking that you refresh my memory. Maybe you buy me lunch tomorrow.
I bought you lunch today.
Actually, that is true.
Okay.
I withdraw. For those who are listening, it's true. Yeah, but you can buy me tomorrow. Sorry, please.
It's
just
okay.
go.
It's okay. So let's go back to December last year. So I wasn't here December last year. So I think I just saw on LinkedIn that you guys made partner. So once you got the confirmation, how did that feel? Your initial thoughts? Because ideally, in a law firm kind of setting, making partner is like reaching the glass ceiling or almost reaching the glass ceiling. So how in the moment when you got the letter, the email or the call, how did you feel in the moment?
It wasn't a call or email. It was a conversation. We were called to Muigai's office. Him and I sat on your chair.
Yeah.
Didn't I?
Yeah. I think I was standing.
The managing partner sat on one, Mr. Mende sat on one seat and he was standing. We thought we were in trouble.
Yeah.
It was something we hadn't done.
Yeah. Because it felt like a scrum.
Yeah.
It felt like...
Then he told us we've made partner, congratulated us. And I remember for around 3 hours, my hand was shaking.
Yeah.
Couldn't process it. We took Mr. Mende and Mr. Nyaoga for lunch, where they congratulated us and told us what is expected of us. We were to keep this a secret until the official announcement, which was how many days later? Was it the next week, I think?
I think so.
And people say we don't keep secrets, but
Yeah,
we
but
can't
we kept
keep
it
secrets.
secret.
Yeah,
We
we
kept
kept
it
it.
secret.
We
Yeah.
kept it secret
Yeah,
until
yeah.
it was announced at the end of your party. But it was fantastic. It made a lot of effort and work feel worth it.
I think I don't have anything to add to that, because I think the feeling was quite similar. I will say, even though you've not asked, that it lasts for just about that.
Yeah.
yeah.
Then the work.
Then now, when you get into it,
Yeah.
you know, there's a lot after it. But you know, in a word, very thankful, very grateful. You know, you look back and it affirms efforts that you have put in, but you also appreciate also the ecosystem that you're working, that has allowed you to grow in that way, and also those who elect to invite you or to allow you to ascend to this new position, because it's not obligatory. It doesn't have to happen, just as you say. So it was a good experience, is what I'd say, for that amount of time.
It's those things where there's joy and then
there's
fear.
Yeah.
There's a sudden realization what you've got into.
Yeah.
Okay, thank you for that. So if you'd allow me, let's go back to the very beginning, at least legally speaking. So it's
like Big Bang.
Not like Big Bang,
Okay.
like Pupilage,
Oh, okay.
but kind of like Big Bang in a way.
Okay.
So it's 20x whatever. David, you're at Mohammed Muigai.
He's saying 20x because he feels we're so old. He can't predict when
Well,
we need Pupilage.
Muigai, you're at Hamilton, Harrison, and Matthews.
Yes.
Your pupils.
Yeah.
Okay. How was it? Generally, before we get to specifics.
You want to go first, senior?
Yes, I'll go first
Yeah.
on this one. I was excited actually when I started out, but then I realized the work was a lot. It was a lot of work. You sort of a narrower view of legal practice when I was in Kenya School of Law, and I'm sure anyone who hasn't interacted with a law firm, the first time you get in, you realize how much work is done. It wasn't easy. Late nights, usual stuff. Late nights, close deadlines. There are a number of times I questioned why I took this profession, but I stuck through it. A lot of people, both my peers, we used to encourage each other, and some of my seniors helped me through it. Yeah.
So, David, just on that point, you've given us a very, how would I put it, a very nostalgic view of the past.
Yeah.
To make it a bit more positive, is a particular time you did something and you felt really proud of yourself during the pupilage time?
A number of times. When you start out, I usually tell pupils, I don't think we did the induction. I wasn't involved in the induction this year. I usually tell pupils, the pupilage process is like when you're building a new building where there was a previous one. So you've built up your knowledge, you've built something, a structure. It works for that time. But now we are coming in, we are saying, this is good, but it can be better. So we have to bring that down and build it up again. So the first document you send, the only thing which will come back, which was your original thought, is the date.
Yeah.
Even the address, you may have gotten it wrong.
Yeah.
Then slowly by slowly, you see more of your intellectual work and effort is being retained. And I just developed that practice of, because people used to do track changes or write it down. So you have two options. You can either adapt without looking at it, or you can read through and see what are they changing. I think that process of adapting, understanding what is being changed, understanding why it's being changed, really helped me through that.
Okay.
And month by month, I got proud of whatever I was
I'll
doing.
get back to you in a minute. So, Muigai, if you could answer the same question.
What pupilage was like for me?
Yeah.
I have to say that I have to answer in a fractured way, or there are two halves to it. For me, my pupilage, every firm does it in a different way. And what HHM was doing at that time, which I thought was very good, is, 3 months exclusive in one department and 3 months exclusive in the other department. And obviously, given what I did now, when I went to the commercial department, for me, it was eye-opening, because I'd never really experienced that before, that type of work. It was very, very, for me, I think it was part of what truly defines what I do today. And so as much as I would want to thank, and I do thank, all the people in the commercial department of HHM at that time, I must also thank all the people in the litigation department, because that's where I started, and they were patient with me. And let's say I gave them reason
to be patient,
to dig deep and find more patience. So especially to them, who I think were quite patient and quite accommodating. I think I would applaud them so very much. In terms of my experiences in both, they were quite enriching. It was just simply litigation wasn't for me, but I think I would say it was an ecosystem where I learned a lot. I think similar of all law firms generally, then and now, a lot of what David is describing was almost a norm. The issue of workloads, the issue of having to learn completely new concepts on the go. Because you move from a situation where university teaches you theory, and then now you move to KSL, which teaches you practical theory. So it's still it's like KSL tries to, and perhaps I'm preempting a conversation. KSL tries to give you what the practice should be, and that's not bad. But now when you go to Pupilage, you now find out this is what practice is. So you come out of an ecosystem where things were a bit more binary. You put in the right answers, plug it in the machine, you'll get the right response. So Pupilage became the point of first contact where things were not that, right? So my experience was one of deep learning. And for that, I will always give thanks. So
deep learning is what you realize those painful moments are after 10 years.
Yeah. It's easy to look back at it now and say deep learning.
So Muigai, as the partner and the head of the corporate and commercial transactions practice group, what in your opinion is the best part about being a commercial and corporate lawyer?
For me, what I really enjoy about my area of practice, I think it, and I'll take correction on this. I feel sometimes litigation can be, not always, because there is usually a dispute, the emotions involved leave very little room for getting to have to really paint on a plain canvas, as it would be, and just be very industrious and see very, very many different ways, not to just provide a solution, which I know you do, but to better understand your client before providing those solutions. Sometimes the time does not allow for that, and you just have to run with what your client is doing, in my experience. So for me, I think what I really enjoy about commercial transactions is building a long-lasting relationship that is pegged on growth, right? That is pegged on positive, helping enterprises and individuals grow from one phase to another phase. Now, I know in many ways litigation does do that, but I think the tools we use are different, and that's actually what I enjoy. So that's what I would say.
Love that answer. So, David, you're a litigator. So, what's the best part about going to court and staying, once you see the cause list, you're number 50 out of 100 or number 99 out of 120, or your matter is under RRI, what gives you that drive to like, you know what, I'm going to stay there, tick every matter, listen in, go defend my client's interests on a more personal and philosophical level for you?
First of all, to begin with, the way that question has been packaged is in a very negative fashion. But that notwithstanding, I will answer it. As Muigai said, we're here to help our clients. And the different practice groups get clients in different positions. Muigai gets a client who wants to enter into a commercial arrangement with someone else for their benefit. A conveyancer or from our BFR team will get a client who wants to purchase a property, for instance, and they need our help so that nothing goes wrong. We get a client most of the time when something has gone wrong. And the way I look at it, they need our help as well. Initially, when you come into practice, you think the help they need is a fighter. But more and more, as you practice more years, you realize what they need is a solution to their problem. Solutions come in different fashions. It can be speedy resolution to the problem. It can be prolonging the problem, depending on whether it's advantageous to them, though that is against what we do as litigators, because we are supposed to help the court to efficiently and effectively determine matters which are before them. Or they can just need advice on how can I solve this. What do I enjoy the most? I enjoy figuring out how can I solve this problem. Take instructions from the client, use my knowledge of the law, knowledge of cases, and try to come up with a solution for the client and try and package it and present it as persuasively as I can for the court and sometimes for the other side, because we also do out-of-court discussions. There's a very wonderful program which the court has started on mediation. And for instance, this year, I think I've had around 3 mediations, and I think they are really helping. So that's what I enjoy in litigation. I will sit there for those 50 matters. I know some advocates, you'll have someone call you just when your matter is about to be called out. I don't take the same approach, and I think Muigai will confirm this.
Even the matters I have with you, I think when I join court, even you're in court the whole time from the start.
I like listening to how the magistrate or judge is handling other matters. How will they deal? How are they dealing with these situations? Then I can have an idea when I put this to them, how will they deal with it? Then I develop. It's just something. It's what I prefer doing. Yeah.
So, random question.
Yes.
Just thought about it.
Yeah.
So, in one sentence, what's that one area for you in practice that once a brief comes, if it's this matter, this is me. No one touch this file. This is my file.
I won't call it an area of practice. Mm-hmm. I'll call it. I've turned into someone from Muigai's background.
from my
the Duchy of Dunbury. I'll call it a novel question, something which I haven't thought about. So it can come in commercial law, it can be employment, it can be land law. It's just something which a very unusual question, and it'll attract me.
Okay.
Yeah.
I like your answer. Safe answer. So let me just rephrase. You give it's a very blanket, very general answer. It's a very someone who's a seasoned practitioner. Because if you ask me the same question, So okay, let me rephrase.
Or can I put it? The last novel issue which came to me, which attracted or caught my attention. Last one I think was 2 weeks ago. And I think I consulted Muigai on it. It's a very complex commercial arrangement. So it took me almost 2 hours to figure out who is who and what is happening. Something which you put a lot of effort in and it rewards you. Yeah. That's what I usually like.
Okay.
Yeah.
So
I'm not giving you the answer you want.
Yeah. Okay. Another random question. Okay. The judicial system, the courts, which is I think the court you like practicing the most in. You feel like this, where you're most comfortable, at least you enjoy the most.
Commercial division of the High Court.
Okay.
Yeah.
Okay, thank you for that.
Yeah.
And again to you, Muigai, I know we work a lot together, I think, on numerous matters. What kind of matters do you think you enjoy most?
Actually, for me, the variables are usually predicated on the client. It's not the size of the client in terms of are they a big conglomerate or the size of the deal themselves. The deal itself, rather, that is before us. I find transactions where the client is willing to, and I think it's something that I've also had to be deliberate about. I would want to always try and provide a service and a structure for whatever transaction that is customized specifically for the client. Yeah. So that's why I spoke earlier about wanting to understand a client and really serve them in that way. Where I find a transaction that the client is willing to put in the same amount of commitment, commitment just being time, and they really want to drill down and come up with something unique, I'm always very, very keen to participate in those sessions. In fact, and maybe you know this, that's why I'm always very happy to have, which is maybe strange for lawyers to commit to doing, but where I can, I'd love to, is brainstorming sessions with the client, where we've talked about the transaction, but they are also going to have discussions with the internal team as to what this transaction will mean later. And usually lawyers don't get involved in that unless it's a risk conversation. But I'm always happy to be involved in those conversations to understand the client's strategy, where they now, because I might hear something that helps me make this better right now, or lend myself to them for something in the future. So it's more about that. For the clients who, no fault of their own or ours, they want something that is a bit more procedural, or something that we've done, or something that they feel doesn't require that depth. Those ones are the ones that I'm less likely to pour more of myself into.
Okay, yeah. Thank you for that.
Just to build up on that, I think it applies to almost all advocates or lawyers. The most important thing is understanding what your client wants. So don't go to your client and start offering them solutions without knowing what the problem is. So it cuts both ways. Understand what they want. If you have a client who's always supporting you, giving you information, let them overload you with information. That's all right. But I think that will help you understand what the problem is.
Yeah. If I can, because now this is how normally we talk.
Yeah.
But this is if I can now also build up on that, because I agree with what he's saying. The temptation we also need to stay away from as lawyers is, you see, normally we try to market ourselves to clients, regardless of which side of the divide you're on, by saying, I have experience in doing this matter, and this is the last matter I did of this nature. Of course, barring confidentiality, protocols. You say, I've done a matter like this. Now, when that gets you through the door, sometimes, if it does, or whether it's a factor, sometimes you then feel almost obligated to do this transaction the way you did your last transaction. Now, the problem with that particular temptation is that it might widen and even get the client. The client also falls into the same temptation. And that becomes a problem somewhere halfway, or even at the end of the transaction or the dispute, where you realize that as much as the circumstances were similar, it required a completely different approach. So sometimes what we are talking about here, about taking time to understand the context, understand what has been provided, and understand the client, that's why it's very, very important to us, not only us as practitioners, but I think even for you, as we've trained you here as a firm, and understanding is something that we're very, very passionate about. So I agree with that guy.
Just to feed off the energy that's in the room right now. So David is a litigator. Muigai is a commercial lawyer. There are matters, as he said, he really enjoys working, maybe doing matters, I think, in the commercial and tax division in the High Court. So he does a lot of commercial litigation. And you could possibly, I think we almost had one, potentially litigious matters, or you've had a few that are potentially litigious that become litigious. So how do you bounce off ideas off each other in that such kind of instances? How does that work in your dynamic?
So that's a very interesting question. Let me, and I realized I didn't give context to this, so maybe I should. So there are two reasons why I never did litigation. One, I'm terrible at public speaking or anything close to that realm. But two, which I think every individual at some point you have to have a conversation with yourself, I don't have that passion. And so if you don't have that passion, you're very unlikely to really delve and pour yourself into certain things, right? You're going to do things at some point, you'll realize you're doing things in a very mechanical way. What's the point of what I've just said? One of the things about David that I've come to appreciate that I never knew before is because of his passion, he spends a lot of time not only reading judgments here, but listening to cases online. Actually, he's one of the few people who I know is listening to or reading about current British cases week on week. Now, why that becomes very important is consulting with him, I have found for me why it's useful is he then does not give me the same, feedback I would have gotten if I went to anyone else. I'm not making a statement about anyone else, but who would have gone and just read a particular judgment. He almost looks at it a little bit three-dimensional. And what he sometimes tells me, which it's easy for me to, from where I sit, not know, is he says, look, I know this judgment is saying this. Yeah. And I know you've picked this particular principle that you think will work in your favor. But from what I have seen and the trends that have been going on in the High Court in X number of weeks, this is unlikely to fly right now, right? And that becomes it requires someone who's very attuned, not to what is happening, but the undercurrents to that, right? And that's what I think, despite his larger knowledge, not despite, but in addition to his larger knowledge, that's what I think he offers. So in terms of how we bounce, like how do we actually do this? I'll give you, a matter you're aware of. There is a capital markets issue we are working right now. And as you said earlier on, which is true, we kind of have an open door policy, David and I. So he'll come to mine, I'll go to his, and it comes up in conversation. So because we also speak frequently, I usually don't have to catch him up on a particular transaction because I might have mentioned it at one place or another. But it's always very interesting in which sometimes I don't consult him. I just tell him what's happening and he cautions me because he knows what's going on. So the nature of our consultation, I would say, is it's quite holistic. It goes beyond saying, what do you think about this clause or not? And sometimes, which is where we spend a bit more time, is strategy. So we kind of zoom out from the granular things and say, from a strategy point of view, it's how we do. Sorry, Senior, if I spoke too much. Do you want to?
No.
Say something?
That was so kind of you. Thank you for the kind words, Mr. Muigai.
To be honest, it's because I'm hoping for lunch tomorrow.
Consider it bought.
Yeah.
I answer the same question?
Yes,
thank you very much. Muigai gives me a different perspective than I have as a litigator. So what I'll do, I'll go and tell him the story. This is what's happening to my client. This is what I think the position is. He'll ask me to break it down. So I won't use any words, plaint, what have you. I'll just tell the story. Most times it's either a commercial transaction. Sometimes it's IP.
Yeah.
IP a lot.
Yeah, we've done some IP.
Yeah, I did my master's in IP. I focus mainly on litigation. Muigai focuses on either giving a strategy for how to protect your intellectual property or gives you a plan on registration, not only in Kenya, but throughout the continent. So I'll go and tell him, this is what's happening to this client. This is what they've been accused of, or this is what they are saying is happening to the intellectual property. The way I understand IP, both here and globally, this is the way the law is supposed to work. And we'll bounce ideas off each other. He's a very useful sounding board. He's just not going to repeat what you told him. He's going to correct you, and in a very delicate fashion. Muigai always begins with, I agree with you, but have you considered this? Or, that's very good. I would add this. It's very, protects your ego. Because he knows you've worked a lot going through a very big file and wants to help you out at arriving at an answer. So I am, one of the pacts we've made with Muigai is our offices will always be joint as long as we're here.
Yeah. At least we get to consult. This is a consultant. Has that answered your question? Because we could have.
No, it really has. I think it kind of comes out clearly how you bounce off ideas with each other.
Yes.
So I think my next question would be, let's touch in a bit more on your masters. So as you know, as a profession grows, as the numbers of advocates or people who want to be advocates increases, there's obviously competition does increase, and there's the need of, trying to stand out, or at least trying to be qualified for various roles. So a master's, as a lawyer is proving to be quite unessential, just like having, your LLB and your PC. So, and the main, I think, issue that comes in, I think, for young advocates is, should I do my master's fresh out of uni, just after KSL, or I wait a bit of time, go back to class, you're clocking 30, going back to class and the likes. So what are your thoughts on that? We could start with David.
Thank you very much. You wanted to go first, Mr. Muigai?
Yeah, it's just how he said, I'm clocking 30. And then
No.
it felt.
I mean, just to clarify, you say the median age for a Kenyan advocate, you finish school by around, 25. You become an advocate by 25. You don't touch like a book to study till then. You're enjoying the rewards of, strenuous practice, once you're enjoying the good money, the lifestyle. So now you think now, ideally, at the very basic, then you're thinking now, okay, should I go back to class? And as you know, law is if undergrad is hell, KSL is the devil, then I think a master's in law is quite, it's a lot. If undergrad in KSL is that hard, specializing in a particular area of law, in a more detailed way, having to do your dissertation again, and you could be doing other things. So what led you to doing that and taking some time off, taking some time to practice, then doing your master's?
Thank you. There are 4 options a student has. 1, don't do your master's. 2, do your master's after you graduate. 3, do your master's after you're admitted. And 4, do your master's once you've gained a few years of experience. And each of those options has its pros and cons. Will your career come to an end if you don't do your master's? No. If you start practicing or you start doing whatever it is you're passionate about, you can stand out and go through the rest of your career without even having to think about your master's. On options, what are the advantages of doing it immediately after undergrad? The knowledge is fresh. It's going to be specialized, of course. You're not going to do everything you did, but it's fresh and it can help you. After Kenya School of Law, you've done your pupilage, you've gone to Kenya School of Law, which has its practical aspects. There is more to the world that you've seen. And also, you graduated only 2 years ago, so it's relatively also fresh. And also, it depends on where you want to do your master's. Do you want to do it here? Do you want to do it abroad? There are various opportunities which you can get on scholarships, and those are available. Can be a topic for another date. I personally chose to do my master's after a few years of practice. Why did I do that? I didn't want to go through master's in the same way that I went through undergrad, where it's theory.
Okay.
I wanted to have practical aspects. Did this help? Yes, it did. I used to, when I was there, I was thinking, I wish my undergrad was as easy as this is right now.
Yeah.
Because I can picture something. When there's a problem which has been set in the examination, I can picture it.
Yeah.
Cons, I had gone through life as the youngest person in my class, always.
Yeah.
Either youngest or second youngest.
Yeah.
I go for masters, I'm 4 years older than anyone else. Yeah. One of the old guys in the class. Felt uncomfortable a bit. I enjoyed it. Personally, I'll go for masters. I'll suggest, if you have the opportunity, do your masters. It doesn't hurt, but have the passion for whatever you're going to master in. Don't just do masters for the sake of doing masters. Think through it. I want to specialize in this. Why do you want to specialize in this? I have a passion for it. Because there'll be hard nights. There'll be very hard nights. If I had time, I could tell you one story.
Yeah.
When I went for I did my master's in the UK. So the first week of master's, I'm walking out wherever I'm staying. It starts raining.
Yeah.
So I pull out my umbrella. I'd been warned. It's a rainy country.
Yeah.
A minute later, the wind comes. It's not too bad.
Yeah.
2 minutes, the umbrella goes upside down. I can no longer use this instrument the way I used to use it back home. Yeah. So now the rain is hitting me on the face. And if you've ever been hit by rain when it's windy, it's like you're being pricked by pins. Yeah. So I have to at least be a bit athletic and run to whatever public means I was using. I get into the first bus. Before I can relax, it misses the turn for school. It starts taking me to the bay.
Yeah.
I just put my head in my hands and said, right now, Muigai is having his second coffee in the office. I don't know why I'm doing this.
Yeah.
But it got easier once I settled down. It was so hard after working to go back and be a student.
Yeah.
So if you're going to do your master's after a few years of work, just remember you're going back to being a student. Yeah, and it won't be easy.
Yeah. Muigai?
I think I want to separate it a little bit. And there's something that both you and David have said, which is maybe I want to deal with together because, actually separate. You're talking about competition in the market. And I think that's where this conversation of masters is coming from. And before we jump to that, I think just dealing with the question of when to do your masters or what to do it in outside of market competition or factors, I would say I agree 100% with David, because the issue of passion, I think, is what will drive you through and through. And I think that can also be said by choosing this profession. And maybe that's a bigger conversation for another time. Speaking for myself, I did, and I'm thankful I did my master's after working, because to be very honest, I didn't know what I wanted to do my master's in. And I remember at the time, because the university tries to incentivize you and tell you, if you choose your master's now, there's an easy transition. There are various small incentives that make it quite, attractive and make sense. I'm thankful I didn't, because I don't think by the time I was finishing my undergraduate, I had any idea that I would ever do anything to do with commercial law. It wasn't in my mind. So I'm thankful for that. And so what I would advise people to do is there's no one size fits all. There's some people who know what they want to do from high school, and you're clear. And if you're clear, then, you're so lucky. Go for that. Now, if you're not clear, there's no harm. That's life. You take it a day at a time. And if you're not clear, take a pause. And sometimes working does help you find that clarity that's needed to choose what you want to do and when to do it. Of course, I'm very alive to other factors that, sometimes it's an opportunity thing where, look, there's this, window of time in my life where I can do the master's now within this year or next year for various reasons. Sometimes there's a scholarship, sometimes there's a vacancy, whatever. And so I'm very much alive to that. But, I think that's something that people need to think about as a timing question. So I would agree with that. I think when you bring the masters into the side of our industry and how there are many lawyers available and it being a competitive edge, I would say not really. I would say, to be very, very honest, I think your master's gets you a meeting. That's all it gets you. It gets you a meeting. It gets you, someone has seen you've put a very interesting thing in your CV. And I'm not watering down what a master's is. I'm just saying now when we come to a competition level, because it'll get you the interview where someone says, this just sounds really amazing, let's hear it. But then our market has gotten to the space where there's many of us, and there's a lot of access to information, and there are a lot of smart people out there. That's just about what you know. It is about what you know. I can tell you the reality is right now, I did, my master's was in international commercial law. I am sure there are people who don't have that degree and know tons more than me by far to date. And the reason for that is there's a drive in them and there's a passion in them for a particular area of law that they continue to consume day on day. And that's what the practice asks of us today. Because why I want to say that, and I think it's important, is people need to detach that a little bit when they get into the working setting. Because now, if you lean on that too much, when you get into you've gotten the job, whatever it is, and you start working, you will get into conversations of progression, conversations of why am I not going for this seminar or that seminar. I'm using as an example. And you realize that your master's or any other sort of qualification you may have is good, but if you don't continue to build on it, it loses value. And once you understand that, you also understand that you can build that value and that competency without the degree. So again, I'm not saying there's no need for a master's, but I think we are getting into a space where people need to know. For me, it's not what is on someone's CV, right? There are people who day on day right now who are consuming so much information that and being able to apply it, that really sets them apart. People who could easily be my contemporary or even lead me on matters, but we don't even have the same qualifications. And I say that as a point of encouragement to very many people out there that should not allow themselves to be defined or pigeonholed by those things. So I'm not saying no one should aspire, but I'm saying when we are on the conversation of competition in the market, someone will get a second glance to their CV for sure. But when it comes to the actual work, I would want a lot of people out there to be encouraged. It's what you know and what you're doing. So I don't know if that helps, because sometimes
It's okay. It
perfect.
helps. That was really, really good. Thank you for your questions. We are now winding up. I want to ask a few, just
I see you've put the scripts down.
no script today. This is coming all from my head. I just do,
Yeah, this is quick. This is the quick fire round.
Okay.
Yeah. So
Are there any prizes?
prizes. Yeah, there's a prize after this. Yeah. Okay. So what's the last thing you read? Book, article that stood out to you within the past 2 months? Nothing for last year.
Last article, there were two books I don't read as often as I would like. However, this gentleman, again, is an avid reader. He'll get to them. I think the last article I read was one which I discussed with you, which was what Meta was facing with their AI in Europe, and how they ran into headwinds in terms of the compliance of that, but the running of their AI and the data protection protocols. The other one, which I don't speak too much on, that we read material and we're going to put out, is on a competition policy. I don't want to say too much because it's something that we're going to put out, but that's what I've read recently.
And I think also, for the audience, I think what Muigai is talking about, I think we're currently researching on large language models and the implications on data protection. So it's a work in progress. So thank you for that.
Yeah, so that was... Well, you're doing more of the heavy lifting than me. I can talk about the one article I read.
Okay.
We've read the rest.
It's a collaborative process for sure.
People are peeking behind the curtain and they're like, so that's how it works.
That's how it works.
When they say the partner, I'm a read hapa. You've done the rest.
Okay.
It is what it is.
David, same question.
I'm very happy that Muigai was very honest in his answer. I was waiting for him to say something he shouldn't. I'm reading a book called Speeches by Lord Erskine. I've read the first 2 volumes. I got the 3rd and 4th volumes just today from the head of our practice group, Mr. Githuu. Wonderful book. His speeches were done almost 200 years ago, but it's so beautiful. You can see the effort which has been put, the elegance of the arguments. And I usually believe there's something which will stick. There's a style which you can gain from it. Articles, I read an article today by Lord Jonathan Sumption, where he's talking about the recent decision by the Supreme Court, sort of expanding the presidential immunity. And it's a wonderful article where he discusses about the interpretation going beyond what the American Constitution had envisioned. I won't take more than 20 seconds. I'm about to geek out. I promise.
I could see the glee in your eyes.
Yes, I'm about to geek out.
Yeah.
You remember the American Constitution came out of rebellion from England, where there was a monarchy. Now, in a monarchy, the king or queen is sovereign. So that's why they're exempt, because they are above the courts. So it's usually the ministers who are implicated for wrongly advising the monarch Think Boris Johnson and the prorogation.
Yeah.
Now, in America, they didn't want anything like that in their constitution. That's why they did not expressly provide for that sort of immunity. But the Supreme Court, what Jonathan Sumption is arguing, Lord Sumption, is that the US Supreme Court has expanded the meaning of the Constitution to be almost like that, which none of the drafters of the US Constitution would have thought of.
Yeah.
So it's a wonderful read for anyone who has time.
Yeah. Okay.
Yeah.
So again,
I kept it short.
You did. Again, the gleam in your eyes. Wow.
Yeah.
Yeah.
Thank you.
Okay. Out of curiosity, what's your best speech so far of all time from the ones you've read?
It's the defense of Tom Hardy. That's the speeches of Lord Erskine.
Yeah, or the speeches, the books, the speeches. I'm assuming the speeches are the
speeches by one advocate.
Okay,
it's called Lord Erskine. The best speech is the last one so far in volume 1 and 2. Defense of a gentleman called Tom Hardy, who was implicated in treason, or what is known as compassing the death of the king. So it's a beautiful speech. And the way he does his argument is that he says, this is not the case according to the evidence. Then even if it was the case, even this is not the case. So he sort of arranges it like a Russian doll, for those who know it. So an argument within an argument within an argument. It's a very beautiful way to do it.
Okay.
Yeah, thank you.
Again, as we conclude, very briefly, what's your parting shot to young lawyers or young trainee advocates? We'll start with Muigai.
I would say I would say be confident. I would say be courageous, and I would say be patient. Those are the things I would say. And I think the context behind me saying that is, for young lawyers, there's a lot of backlash or commentary, maybe it's generationally informed, in which you are told that you are too impatient, that you sometimes, I don't say lack focus, but move from one element to another and so on and so on. Now, I think some of those statements are a bit harsh, but I think they're partly true, informed by certain things. But I don't think they're necessarily a weakness. And so that's why I would say that, to any young lawyer hearing it, whatever sort of circumstance you find yourself in, that is, within that line of sentiment, I think be confident enough to receive that in whatever way it's meant, but also confident in knowing who you are as a person, because even if, let us assume those things that are being said are true, it only makes up a portion of who one is. So there are various other things. So then I would say to be courageous enough to push through, to take, I think the expression is, you take the good and the bad, generally speaking, in any circumstance, not weighing or accepting or denying one over the other, but making something of it and then moving forward. And that's what I would say, to have the courage to do that. And then to just be patient with the process. Patient doesn't necessarily mean slow. You may be of a greater pace than I, or in whatever thing, but it is what you do while you're in that transition. So those are just the things I would say. And this market is big enough for all of us. We all want to work together. So I think no one should hesitate to ask for assistance.
Thank you for that, Muigai. David?
Thank you very much. The first thing I'll say, don't think you are the first ones to be told that you're impatient. I saw comments that you don't read. I saw some people saying that you don't address the court properly. We've all been told that. Is it justified? No. But every generation will try and say something about the generation which is coming up. Sometimes they may see the bad faster than they see the good. Some of them are very aggressive. Some of them, there's nothing wrong in opening your law firm after a few years. If you have the ability to do that, if you can take care of a client's brief, if you can take care of a client's funds, go for it. If you have the ability, go for it, do it. Patience depends on perspective. So my patience, or what I think patience is, may not be what someone else thinks patience is, or what the situation demands. What is important is putting the work in. The work cannot be avoided. If I tell you that there's a shortcut to avoiding the work, no, it'll catch up to you. So put the work in and do everything at your own pace.
Thank you so much, gentlemen, for that. It's been a pleasure having you and gathering so much from your insights.
Thank you. This was wonderful.
Thank you.
Yeah.
Okay.
You look like you had a good pupil master.
Right? Yeah. I know. Thanks.
I doubt this will be your last interview. Well done.